If you're a landlord in Illinois, 2026 is not the year to just wing it, because landlord law enforcement and tenant protection continues getting stricter, especially in the area like Cook County and Chicago. And the reality is a lot of landlords are still operating based on outdated information, and that creates the risk. We're talking fair housing complaints, security deposit violations, improper screening practices, and expensive legal mistakes. So today I'm going to walk you through some of the biggest Illinois landlord updates and trends you need to know for 2026. And honestly, this is exactly why systems matter more than ever. Hello, I'm Gabi Witas, owner of Nex-Gen Real Estate and Property Management, helping landlords in Chicagoland navigate the rental scene. And this video is also a small preview of the type of real-world landlord education I cover inside my Landlord Shield course, because Illinois landlords need to stay proactive and not reactive. Let's jump into it. Number 1, the new Safer Home Act disclosure requirements. Starting with the one that many small landlords still don't know about, Illinois now requires landlord to provide a summary of rights disclosure relating to the Safer Homes Act with new leases and renewals. This relates primarily to protections for victims of domestic violence and similar situations. This includes things like lock change rights, certain lease termination rights, landlord response obligations. And here's why this matters. Failing to provide required disclosures can create liability. A lot of landlords focus only on collecting rent and filing vacancies, but paperwork and compliance matter just as much. The source of income protection. This is another huge one, especially in Cook County and Chicago. Landlords need to be extremely careful with how they handle applicants using housing vouchers, disability income, public assistance, other than non-traditional income sources. You cannot simply blanket deny someone because they use a voucher program in many Illinois jurisdictions. And this is where many landlords unintentionally create fair housing risk. Consistency is everything. You need clear written criteria, consistent processes, objective screening standards. And honestly, this is one of the reasons I'm such a big believer in structured systems, because emotional or inconsistent screening is where landlords get into trouble. And if you don't have a step-by-step system screening process in place, that's exactly why I created a free checklist. It walks you through core steps landlords should be following to protect themselves and stay organized. And the link is in the description below. Next is the security and deposits and fees are under more scrutiny. Illinois continues moving forward heavier regulations around landlord fees. This includes move-in fees, application fees, security deposits, and the administrative charges. And lawmakers are paying more attention to transparency. There are ongoing pushes to limit and regulate excessive fees, double charging structures, and unclear lease charges. So if you're charging move-in fees, pet fees, administrative fees, utility fees, make sure everything is clearly documented, properly disclosed, and legally compliant for your area. And remember, Chicago rules can be significantly stricter than surrounding suburbs. Number 4 is the minors cannot be named in eviction filings. This is another important update. Illinois changed procedures relating to eviction filings involving minors. Minors generally should no longer be listed as defendants in eviction cases. Now, this doesn't mean occupancy records are not important. You still absolutely want accurate occupancy documentations, but landlords need to be careful with how filings are handled legally moving forward. This is another example of why relying on old lease templates or outdated practices can become very risky. Number 5, the squatter law changes. This has been a major topic recently. Illinois passed updates that may allow law enforcement to treat certain unauthorized occupants in vacant properties as criminal trespassers in specific situations. Now, this is important. This does not replace standard eviction procedures for actual tenants. A lot of people misunderstand that online. But for truly unauthorized occupancy situations involving vacant properties, this may help property owners regain control faster in certain circumstances. Vacant properties continue being a major risk area for investors, especially if properties sit empty for extended period. Number 6, the security deposit compliance continues getting stricter. And honestly, this is where I still see a lot of landlords make mistakes. Illinois and especially Chicago continue heavily enforcing security deposit timelines, itemized deductions, documentation requirements, interest obligations where applicable. And here's the scary part. Sometimes landlords lose these cases even when the tenant actually caused damage because procedures were not followed correctly. That's why documentation matters so much. Photos, move-in reports, written communication, everything. A casual approach to management is becoming increasingly dangerous in Illinois. Number 7, we've got Chicago RLTO enforcement. If you're a Chicago landlord, you already know this one. The Chicago Residential Landlord Tenant Ordinance, or RLTO, remains one of the strictest landlord environments around. This includes requirements involving lease disclosure, heat requirements, security deposits, summary notices, repair timelines, and tenant rights documentation. And penalties can become extremely expensive. The biggest mistake I see, landlords assuming they're compliant because they mostly follow the rules. Unfortunately, mostly compliant does not help much if you end up in court. You need systems, you need procedures, and you need consistency. Number 8, criminal background screening continues evolving. This is another area landlords need to handle carefully, especially in Cook County and Chicago. Blanket denials for criminal history can create fair housing concerns depending on the type of offense, how old it is, whether it is irrelevant, and how consistently your policy is applied. This does not mean landlords cannot screen for safety concerns. It means you need to be thoughtful, objective, and consistent. And this is another area where many landlords unintentionally create problems because they rely on emotion instead of policy. Now let's zoom out for a second. What's the overall trend here? Illinois landlords are increasingly expected to operate professionally. That means written screening criteria, proper disclosure, consistent communication, documentation processes, and legally compliant systems. The day of, I'll just figure it out as I go, are becoming very risky. And honestly, this is one of the biggest reasons I created Landlord Shield, because landlords need structure, clarity, and real-world guidance. Inside my course, I go much deeper into tenant screening, fair housing, documentation compliance, income verification, lease protections, and red flags landlords should watch for. Because one bad decision can cost you thousands of dollars, months of stress, and a huge amount of time. If you take one thing from this video, let it be this. Illinois landlords' laws are evolving quickly, and it's your responsibility as a landlord to stay informed. And if you're in Chicagoland area and you're looking for help with tenant placement or property management, we're here to help. Because at the end of the day, the landlords who stay profitable long-term are usually the ones who stay proactive, organized, and compliant. And 2026 is definitely the year to tighten your system. Thanks for watching, and as always, where's your future?